The way that you always have to approach this question is you first have to look at the facts of the case, and you first have to determine whether a prosecutor can even prove that a theft occurred. If the evidence is sufficient to prove that the theft occurred, the prosecutor then has to prove that the defendant was the one who committed it. If those two things go together, then we start breaking apart the specific facts to discern exactly which type of theft crime can they prove occurred. For example, the most commonly known thing these days is that grand theft is distinguished from petty theft, and the distinguishing line is a value of $950. And so the prosecutor also has the burden of proving that the object stolen had a value of at least $950. That value can be determined by many things: retail prices. Some judges are actually open to the value of the item regardless of the sales price tag. So what is the cost of manufacturing that item, of transporting that item to stores? What did the store owner, the victim of the theft, what is their actual loss by the theft of that item? Sometimes it's not always the price tag, but some judges do go strictly by the price tag. The difference between a robbery and a theft, and a regular theft: a robbery involves a theft, but a robbery is a theft plus the taking by force or fear, by the use of violence, or the use of a threat, something that prompts a victim to involuntarily part with their property. A taking from the person of another, if not by force or fear, is grand theft from a person. So the distinguishing feature, as I mentioned, between all grand thefts and petty thefts is the value of the item. So you can take an item from a person that's in their possession, but without using force or fear to take it. And if the value is less than $950, then that's just a petty theft. In Oakland, I've represented many people who've been accused of stealing from marijuana dispensaries. Usually these people go in after hours. Sometimes they go in with weapons. Obviously, if you go in with weapons, it's a robbery. There's no question about it. It's a robbery because you bring their weapon to use force or fear in order to take the property. If you go in after hours, it's a burglary. The taking of the property itself is not the burglary. The entrance is the burglary. And so it's possible that you can actually take less than $950 worth of merchandise. The the theft charge, if it's under $950 in value, the theft charge would be a petty theft, not a grand theft. However, the case would most certainly be charged along with a felony burglary charge, because you cannot break into any building, let alone a business, after hours to steal its merchandise. In San Francisco, I've represented numerous people charged with petty theft and grand theft. Most recently, I was one of the attorneys in the Louis Vuitton break-in, where about 50 people broke the glass doors to a Louis Vuitton store in San Francisco, entered, stole tons of merchandise, and I think the police only managed to arrest about 4 of them. I represented one of them who was seen on many news stations with his car windows being bashed in. The issue there was whether he was the person who went in and whether he actually took anything, if and when he did. Now, the funny thing about a theft from Louis Vuitton versus a theft from Walgreens is you can take the same amount of merchandise from either store. You can even take a lot more merchandise from Walgreens than from Louis Vuitton. But what's going to happen in Louis Vuitton is most likely that one item is worth more than $950 just based on the store tag alone. And so it's very unlikely that someone can walk into a Louis Vuitton and commit a petty theft. Whereas someone can walk into Walgreens, grab a shopping basket, walk up and down the aisles, pushing all the merchandise in their cart into their basket, walk right out without paying, and it's still petty theft because the value adds up to less than $950. That's the state of the theft laws in California right now. I've represented numerous people doing each. The district attorney in San Francisco has really eased up on prosecutions for petty theft crimes. And he's received a lot of flack from it. A lot of store owners, businesses are saying he doesn't do enough to help them. There is a counter argument that a lot of stores, such as Walgreens, could afford to bring in security guards, but don't. The net effect is not necessarily that people are getting away with it. He is getting blamed for a lot of the crime that's happening. But the net effect is that a lot of people who do get arrested for it get diverted, get put into a program where their problems that cause them to commit petty theft in the first place are addressed, rather than punishing them by putting them in jail or giving them a criminal record, which can only lead to recidivism and put them in a hole that's hard to get out. The Louis Vuitton store obviously is much more difficult to defend based on the value of the merchandise. As I mentioned, all you have to do is basically steal a t-shirt from Louis Vuitton and the value is more than $950. So in that case, the defense is more about identity and more about whether they can prove that my client actually did enter the store. And if he did enter the store, did he exit with merchandise?